I think it's fair to say that a lot of city managers are very naive to the legal dynamics that are out there swirling against us when it comes to being in a very perilous situation that you found yourself in.
You don't have any friends. You don't have any allies. You don't have what you believe to be as a network of support is really a false sense of security.
All right. I'm Joe Turner, and this is City Manager Unfiltered, a podcast by a city manager for city managers and other public sector executives. This is part 2 of my interview with Daniel Rosemond, the author of Death of the Public Servant. He's the former city manager for Hallandale Beach, Florida, and he was part of a wrongful termination lawsuit against the city of Hallandale Beach. He wrote the book documenting his story, and we are going to go into part 2 of this interview, and that is the revenge of the public servant. And this is where our hero goes and kicks some butt against the city in court. Daniel, welcome to the show, and thank you for being on.
Thank you, sir, for having me again. Appreciate it.
Absolutely. I thought what I would do real quick, Daniel, for the audience benefit is just go through a quick little rundown of the timeline to kind of bring us up to speed and just sort of the big picture. So in November 29, 2016, that is when the elected body, the Hallandale Beach Commission, even though the election had not even been certified, but you had a council member who was seated, and then they proceeded to ram through on a 3-2 vote your termination with cause, which means that you were not subject to any severance protections or anything like that. You were just basically kicked to the curb, and you have to fend for yourself. That happens on November 29th. But because of your city's charter, they have to hold a hearing on December 28th to give you some sort of opportunity to answer to or respond to this termination. It's a little bit of a sham deal, as we've talked about already. We might get into a little bit more here. And then you were basically left to fend for yourselves at that point. Your first court hearing isn't until July of 2017, as I understand it. And that's when you and your legal team were essentially battling against the city's attempt to just dismiss your case. That was like the first attempt to stall. And then you got to fast forward to March 16th of 2020. That's when your actual legal case is set to be heard by a judge. But then it gets thrown up in the air because of this thing called the COVID pandemic, right?
Yeah, yes, sir.
And you're put into this another state of uncertainty and ambiguity with your life. So your case goes all the way to February 2022 before it gets heard. And that's when you go through a 9-day trial, correct?
Correct.
Okay.
Correct.
And then that's where you kind of leave off in the book. That's where we're kind of left, right? So can you walk us through what happens real quick for the audience? What happens after February 2022 when you win your court case?
Well, there was obviously a lot of elation from an emotional standpoint in terms of what happens. I would say for the first month and a half to 2 months after the jury's verdict, I was really in a state of kind of disbelief that A, we had gotten to that point after all of the delays, and B, that we had actually, won in such convincing fashion. It was really amazing. But there was another component to our complaint, which was the front pay component, which was always supposed to be part of the original trial. Our complaint consisted of the wrongful termination and the whistleblower complaint, as well as a front pay component. Anytime that
Okay.
you have a wrongful termination, the defendant, in this case, the city of Hallandale Beach, has the ability to present to the court how they are proposing to mitigate if in fact they are deemed to be wrongfully at fault. So they could have offered me a job back, which is what they did in court, or B, we offered the fact that I didn't want to go back. It was a hostile environment, and so we claimed that there should be a front pay portion, meaning how many years in advance should the city compensate me for what they did. And so that was a bench, what's called a bench trial. So there's no jury in that situation. It's just a judge. And we present evidence, we present relevant cases, and the judge made a determination and provided a front pay amount that the city is also responsible for.
So Daniel, sorry to interrupt you there, but so my understanding is that there were 3 segments or components to your judgment, not your settlement, but your judgment, right? There was the breach of contract, which was that $92,000 sort of severance clause provision that you were denied when you were fired with cause, right?
Right.
And then there was the 3 million component for non-economic damages. That's an aspect that we'll get into later on in the conversation. And then is the front pay referring to the 1.3 million part of this judgment, or am I misunderstanding that dynamic?
Yeah, no, the 1.3 was actually the back pay. So everything up until that point, the way it's calculated is that the defendant, if the jury deems them to be at fault, is responsible for my back pay. So not only did they pay me the contract that I should have gotten, but because of the wrongful termination, I'm also eligible for back pay. So from the date that they terminated me, December 28th, 2016, all the way through February, whatever the date of the jury trial was, the city had to calculate or had to pay me that. And we had
Got
a
you.
an expert witness who provided the economic breakdown of how that was calculated. So they took into account everything that I had earned on my own through my real estate or whatever consulting that I had done up to that point. And then they, factored in things like interest and all of those financial components. So that was the back pay component.
Okay, got you. Okay, so the front pay then is something that's not even discussed in the book. It happens after the book basically ends, so
Is
to speak.
released.
So what happens in court when you are with this bench trial with the judge? How does that go for you?
It goes well. The judge, I mean, we didn't get everything that we wanted. We wanted a certain number of years, and the way that front pay calculations are done, everybody I think approaches it a little bit different. But because of my age, I'm already in my 50s, and we claimed that I had wanted to work until a certain point of my life. And so you factor in how much I would have been earning given periodic merit increases. And the way that I
Right.
calculated it was that I maxed it out at a certain number. And so the judge looks at that evidence. Obviously, he looks at the evidence provided by the defendant and comes up with a number. It wasn't the number that we wanted, but it was a number. And so when
Okay.
you factor all that in, it's the total amount that the city is now liable for. And so it brings us to the point of their filing the appeal. So after the front pay hearing, the city proceeded to file their appeal of all of that, which is where we are today.
Okay, and this is where it gets a little bit hazy for me. Okay, so I hope you can unpack this. So the jury finds for you on the three components that we talked about. There's the breach of contract, there's the back pay, and then there's the non-economic damages. Then you go to this bench trial with the judge, and the judge finds in your favor for the front pay. So there's four components to your monetary settlement or judgment. I don't want to use the word settlement because you won in court, you didn't settle.
Right.
That's a fair, that's proper
That's
vernacular, right?
absolutely accurate.
Right. Okay. So you have this judgment, two different judgments that are basically in your favor, and there's four components to it. Now, Hallandale Beach is appealing these judgments, these court cases, these court awards or whatnot. Are they appealing all four components, or are they
Yes.
appealing? They are.
Yes.
So you literally have not received one penny of these victories at all. Is that, am I understanding that
Not
correctly?
not even a an attaboy, good job, congratulations, nothing. We not only have I not gotten anything, but my attorneys have not been paid.
That's what I was just going to get into too, as well, because obviously, as you talk about in your book, they work for you on a contingency basis, right?
Yeah. Yeah.
So, okay, so we're going to come back to that in a second, but I think it's very important for people to understand because you have not received one penny, even though you've received a multi-million dollar victory in court on two separate instances, one with the jury and one with the judge on a standalone bench trial. And yet you still have not received one penny. I think there's a lot of people out there who have this misconception that just because you won in court, everything's great in Daniel Rosemond land. I mean, here we are, we're 7 years later and you still haven't received one penny, right?
Not
Uh,
only have I not received one penny, but the fact that the all four components are under appeal, there's the threat that all of that could essentially go
Go
away,
away.
because when you go to appellate court, it's a different set of players. So the Fourth District Court of Appeals, which is the particular court that is hearing this case, could very well determine that the judge, the jury, the trial itself was incorrectly tried, and could determine, This is one of the things that in the city's motion could determine that the trial has to start all over again. If you put that into the context of anybody who's read the book to understand the emotional toll that it takes, just the mere inkling or the mere possibility that we would have to do this all over again is almost like, okay,
It's traumatic. It's very
it's
traumatic. I
I'm
mean,
I'm about to slip my wrist, that
yeah,
type of thing.
yeah, absolutely. I mean, I can't imagine the stress. I mean, because yes, you have the elation of victory, but you always have that fear that it can be the rugs can be pulled out right from underneath you once
Correct.
again. Yeah,
Correct.
and you never know with our justice system. I mean, you just never know. I mean,
You
it's
don't.
so
You don't.
okay. So we have a quick update on where you stand now. Dan, you've gone through something that very few city managers will actually go through in their career. You have a very unique life experience, a very unique perspective on this whole entire situation. When so many city managers are listening to this podcast and they don't ever want to be in your shoes, right? When did it dawn on you? This might be a really dumb question, but when did it really hit you smack in the face? I need to get an attorney.
Man, that's for a while this thing was happening, going back to your timeline synopsis, when this thing was happening at the beginning, I thought, I don't need an attorney, man. I mean, I can defend myself. I've been a city manager, been in enough scenarios with the council or the commission to know how to essentially put together my own presentation to debunk the ludicrousness of the three stated reasons.
Right.
But it was in conversation. I can't remember even who it was with, but in conversation, somebody says, you probably should get somebody to just represent you. And I kind of haphazardly reached out to somebody who's a friend, number one, but secondly, he had been an attorney who I had worked with in a previous city doing labor negotiations with our union. And he's a labor attorney. And I said, hey, man, would you deal with this for me? And he's like, sure, no problem. It should be a pretty easy thing because an employment agreement. So it was always intended to be a real, easy thing. Just draw up a separation agreement and be
Because
done with it.
this is the gentleman in the episode one. You talked about how you had this separation agreement drawn up when you went in to
Right.
talk to London and whatnot, and you thought it was
Correct.
easy peasy, right? So this is the
Correct.
gentleman that you talked to about being on your side before you actually were officially terminated, correct?
Right. Freddie.
Okay,
Freddie Pereira.
okay. So you have Freddie
Yep.
Pereira helping you out before you get officially terminated, and then after you're terminated on November 29th, and you start realizing, okay, this is going downhill, and we have this hearing coming up in December. I think you reached out to additional, this is where you consulted with two different firms, I think, to try to get representation for you at the hearing as co-counsel or something
So
like
so
that,
let me
right?
so let me let me provide a little bit of context. Freddie, who was my attorney at the time, was working with his previous law firm. At the time, we all thought that it was going to be a pretty simple thing. When I talk about the fact that we had wanted to extend the presentation beyond the December 28th date, Freddie was still my attorney and he was going to be out of the country. But because the city commission decided, no, we're going to stick to that date, at that point, Freddie says, listen, I think we need to get a separate set of counsel because I'm not going to be available. Number one, I'm going to be out of the country. Number two, another element which I don't get into in the book, he was in the process of actually separating from his law firm and going off on his own. So he was like, if this thing goes sideways, we really are going to need co-counsel just to help because I'm going to be busy trying to find office space, yada,
Right.
yada, yada. And so we reached out to,
Well, and Daniel, if you don't mind my interrupting there, I think there's also a third component too, because wasn't he also working for a firm that was intimately involved with a bunch of other municipal governments,
yes,
and so you had you had this conflicts of going all, it's a very small world in municipal attorney land, right?
yes, sir. And in fact, the day of my court victory on the way home, Freddie calls me, right? And he heard about it from my attorney. So he calls me and tells me, hey, man, congratulations. He goes, I've never told you this, but the decision for me to go off on my own was because my firm did not want to represent you. And I
Uh,
had been on the fence about wanting to go off on my own. And when they said, no, we're not going to take this because it's going to jeopardize our clientele, that was what solidified it for me. He goes, in my spirit, I knew it was time for me to go off on my own. So he says, I've never told you that until today. And I was like, wow, I didn't realize
Wow.
that, because
7
I
years
wouldn't have wanted,
later. Yeah.
yeah, I wouldn't have wanted that kind of pressure. But he says, no, no, it wasn't because of you. I was already thinking about it. Your case was what really just kind of solidified it and took it over the top for me, in terms of me being able to go off on my own. And he's been enormously successful with his own practice since that time.
Awesome. We're going to have a third episode called The Betrayal of the Public Servant. So I don't want to give anything too much away, Daniel, but in reading your book and having this conversation, our offline conversations, our pre interview prep, I think it's fair to say that a lot of city managers are very naive to the legal dynamics that are out there swirling against us when it comes to being in a very perilous situation that you found yourself in.
You don't have any friends. You don't have any allies. You don't have what you believe to be as a network of support is really a false sense of security. That's
Yeah,
how I would put it.
Well, yeah, we're gonna dig into that a lot more. The third episode is gonna be explosive. So if you're listening to this episode, you need to make sure you tune into episode 3 because we're gonna talk about the betrayal of the public servant. So Daniel, I think now would be a good time to kind of talk about the maybe introduce your legal counsel, maybe for the people who are listening, so they can kind of follow along. Because I know you have a legal team that you're very proud of that represented you through this case on a contingency basis, and we're gonna get into that as well. So can you just give us the key players so people can follow along at home?
I would. And then let me back up for just a minute. So early December, Freddie was still my attorney. He was had told the commission that he was going out of the country, but he was at the time considering starting his own firm. So he gives me a few names for me to interview. And I was eager to try to find someone to be able to just be on board. So my wife and I go in and interview this one attorney that he had sent. She's a sole practitioner, had some court experience with dealing with the federal government cases, etc., and sends me her engagement letter. And I'm actually in my home office at the time, ready to sign the engagement letter because I just wanted somebody on
On your
board.
side, yeah.
And Freddie calls me at the time. He says, "Hey, have you signed that engagement letter?" And I'm like, "No, I'm about to." He goes, "Don't do it. There's one more person that I want you to talk to." And I said, "Who is it?" He said, "It's a guy by the name of Brian Lerner. He works with a firm, Kim Von Lerner. He's a board certified, top notch labor attorney. At least talk to him. And if you decide to go with Gina Cadogan at the time, then it's your call. But at least talk to this guy." So I'll never forget. And I think I talked about this in the book, but my first conversation with Brian Lerner was at a Publix near our old house at around 4:20 in the afternoon. He calls me and we had about a 20-minute conversation. Nicest guy, really focused in terms of just what the law dictates, what can be done. He didn't make any false illusion. It wasn't a sales pitch. It was really more, hey, this is who we are. This is what we do. We'd be honored to represent you. We've read, kind of the brief of your case, and it would certainly be right in our wheelhouse. Didn't have any kind of restrictions in terms of going representing me against a municipal defendant. And so I went back and talked to my wife about it, and she's like, I think that that's who we want to go with. I wasn't really feeling the other attorney. And so we ended up engaging Kim Von Lerner, and they were represented by the two of their principals, Robert Vaughn and Brian Lerner. Those were the two attorneys that actually came to my defense in that December 28th meeting. It was a transition because while Freddie was my initial attorney, because of the issues that I described, Kim Von Lerner came in and they represented me during that December 20th. So they got up to speed not only in short order, but right around the holidays. So I was floored that they would have been that available, number one, but willing to really put in the work because they put in a significant amount of work.
Well, not just willing, because did it on a contingency basis, right? And so a lot of us have heard about what contingency basis is, and in simplistic forms, we all understand it to be that, hey, they only get paid when they win in court, correct? Is
Correct.
that
Correct.
literally how it happens? I mean, have you had to pay out any money at all? I mean, anything at all out of your pocket since this whole thing happened?
Well, yeah, I did pay initially. There was an engagement that I paid to Freddie's firm initially when we
Right.
engaged him, and then there was a small amount that I paid to Kim Von Lerner at the beginning. but the lion's share of all of the legal fees have been essentially taken. Our case was taken on contingency, which, when I think back, when I talked in the previous episode about seeing God at work in this whole situation, this is one of those instances because they didn't have to do that, number one. And I think about what it would have cost us as a family had we had to pay the legal fees. There's no way that we
It
would
would
have
have
been
cost
able
you
to,
everything. Yeah.
we wouldn't have been able to make it. I
Yeah.
mean, it's as it is, our circumstance has been stripped back. But if we had added legal fees to that in the course of 7 years, there's no way that we would have been able to survive, not even the first year of this litigation process.
So when they took it on a contingency basis, forgive my ignorance because I've never been down this road and I don't even know how much you know about this outside of your specific case, right?
Hmm.
Is it common or uncommon for attorneys to take cases like this on a contingency basis versus a retainer or whatnot? Do you have any insight on that at all?
Usually, what you find on contingency is the ambulance chaser
Yes,
type cases,
right.
the slip and falls type cases where, you've seen the ads as well as I have and your listeners have. You know,
And,
we,
but
we, we only get paid, we'll represent you, and we don't collect
right.
unless you get paid. But
But but
on a,
but can I interrupt you there, on the Daniel? Because
sure.
what's going to happen though is on those cases, these attorneys have experience with these cases. They've done so many. They have a pretty good idea of what they're going to be able to settle because most of them get settled before they even go to court, right?
Right.
So they have a pretty good idea of what the expected value of the case is relative to what they're going to put in. And it's a formulaic decision. When you come to a situation like yours, it's very unique. It's very hard to quantify. You throw in the element too, and this is something I think the listeners need to think about as well. You always have a dicey element when it comes to an individual suing a government agency because a government agency represents taxpayers, and you never know how that's going to play out in a jury box. Or am I right? Am I wrong on that? I mean,
Absolutely, man.
okay,
Absolutely. It's a very unique. Yes, it's a labor dispute, but it's not like
it ain't you, this
Joe.
big bad Fortune 500 company,
Right, right. It's not Joe Turner versus Amazon or Joe Turner versus, Macy's or some other big corporation that typically will look at the cost benefit analysis of saying, well, why are we even litigating? It's like, okay, just pay the guy and be done with it because it's too much money to deal with it. But then there's also the element of the jury pool consists of the very taxpayers that are paying
impacted by
into
the.
impacted by the decision. So it's really one of those things. Is like, okay, that element, all of those things were, as I was sitting in during trial, all of those elements were swirling around in my head because I'm thinking any of these jurors are going to conclude, okay, if we award this person, even though they were not any Hallandale Beach residents who were on the jury pool, they were residents of Broward County. And
Right,
so Hallandale Beach is a city in Broward County. And
right.
so because of what we understand, most taxpayers don't understand the nuances of that. I'm thinking they're going to conclude, okay, if we award what this person is claiming, we're
I'm
ultimately the
paying
ones
for it.
having to pay
Yeah,
for it.
yeah. Yeah, it's a very interesting dynamic. So, what do you think Mr. Lerner saw in your case that, or the firm that, what gave him confidence to take your case on a contingency basis? That's a big commitment. That says something to me. That tells me that they have to have some strong probability or belief that your case has merit.
Yeah, I believe that they saw all of the evidence. I mean, the other element of cases like this that are unique is that when things are done in the public realm, and in my particular case, all of the statements, all of the documentation, all of those allegations were done on the record. So it wasn't anything that had to be mined for in discovery. It wasn't any backroom discussions or anything like that. A lot of the things that were mentioned were done on the record during a public meeting. So when they reviewed that, it was a very strong case. And so they determined that, hey, this is a type of case that the nature of the wrongdoing by the municipal government to an individual was so severe and so pervasive that it was the type of case that they wanted to take on.
Right.
Now, they've said to me, we're very selective when it comes to the types of cases that we take on. Yours was one that rose to that level to not only consider it, but then to take it on contingency was amazing. Like I
And
said, if
yeah,
I had had to pay for it, there's no way that we would have been sitting here right now.
And also too, what kind of morale boost did that give you and your family when you have these independent third party litigators who are saying, "Hey, we want this case. We think we can win this case for you, and we're not going to charge you for it." That must have been a huge more boost of morale in the household, I would think.
It was amazing. Just to think. Actually, we were not. It wasn't a morale boost as much as we were humbled by the fact that they were willing to do it. Because at that time, our confidence, my confidence level was really pretty thin, and even though I knew that truth was on my side, when you're up against a municipality with seemingly unlimited resources and time, I knew that it was really, kind of a David and Goliath type of situation, and it was really an uncomfortable type of thing. So the fact that they took it on contingency, and to this day, I feel completely, beholden to Brian and to Robert and Anisha and the entire team, really, because they not only took the case, but they embraced us really from an emotional and a personal standpoint. So every conversation was, "Hey, how are you guys doing?" Before
Right.
we got into any of the specifics of the next task, it was really about, "How are you guys doing? Is everybody okay? How are the girls?" So they were always very sensitive and thoughtful in those conversations, and so they've become, as I wrote about, they've become like our extended family.
Yeah, there's a poignant moment in your book where you talk about, I think it's Mr. Lerner. You after you win your case in that February court case, he, I guess, comes out into the lobby area and you just see him sobbing on his own on a bench or
Yeah.
something like that.
Yeah, it
Yeah.
was it was let me tell you, it was surreal because I was dealing with my own emotion, but in that moment I took a mental picture. I realized there had been, and I never did ask him. To this day I haven't asked him, why were you so emotional? And I think that there had been as much invested in this case from them as I had invested as a plaintiff. I will never know the number of hours and the endless nights and weekends that they work trying to prepare and do all of their due diligence in terms of representing me. I mean, if you would have seen the volumes and volumes of documents that they brought to court every single day, it was amazing. I mean, I had never been inside of a courtroom like that as a plaintiff or a defendant. It was just really amazing to watch, and it was almost surreal from the standpoint of, I can't believe this is actually happening. But these guys were just amazing warriors on my behalf.
Well, I have a little bit of a tacky question that I'm going to couch in for the further advancement of the profession and educational purposes, right? So, how do they get paid? Do they get paid a percentage of your ultimate judgment, or do they get paid based off of their cost or whatnot? How does that dynamic play out?
Well, there's the fees are set by, I believe it's set by state statute, if I'm not mistaken. So they can't just charge whatever they want to charge. They have a percentage that they can recover based
Okay.
upon the outcome of the trial. Now, what's
But does that
interesting
come? But
about,
does that come out of your money
no,
that you've been awarded? So
it's
they're
no,
they're going
it's
to be
on top
paid.
of that.
Okay, so Hallandale Beach, if they lose this appeal, they're out the 4.4 million plus the front pay verdict and the cost to your attorney, your legal team.
Plus their own legal team.
Yes, of course. Yes,
which
they're out
is
that already.
which is the really, bananas part, right? When we talk about the types of decisions that, governments or local governments make, think about it from the standpoint of just purely financial, right? It's like, okay, maybe we didn't want to pay, think about it in baseball terms. You sign somebody and the guy ends up being a bust, but he's got a contract. It's like, okay, all right, it was a busted, draft pick, but let's just pay him and be done with it. Because
Yeah,
ultimately, you're going to lose and you're going to incur additional costs with regard to your legal fees. And so it's just really a phenomenon that I don't understand, partly because I think the rationale is we don't want to allow a precedent to be set that, hey, we can be sued, and we
yeah.
want to discourage anybody else from doing it. But also, it's just, I think, egotistical to think I don't want to just kind of roll over, even though one of the elected officials had decided, well, when Mr. Rosemond has his day in court, he'll have an opportunity to, state his case, which we did that, and now they're deciding to appeal.
Right. There's a sick joke in the whole idea that so far the only people who've got paid are the defense attorneys.
Yeah,
You know what I
Yeah,
mean? They get paid.
they get paid no
So
matter what. And
yeah,
to their benefit, it's almost like they're in the room, right? These shade meetings, they're in the room telling their client, well, we want to encourage you to appeal because yada yada yada. Well, part of it
of
is,
course they're
yeah,
getting
we
paid.
want we
Yeah,
have more billable hours that we can submit, right? So it's
absolutely,
like,
absolutely.
hello.
So I don't know if you know the answer to this question or if you've even gotten your head to that point yet. But since you received the breach of contract severance pay, which is income, and you have the back pay and the front pay, are those three components subject to your typical federal income taxes once you get that victory? Do you know about that? And how does that
Yeah,
relate to what about the non-economic damages? Are those subject to taxes as well, or is that tax free?
the non-economic damages is not, because I did consult my CPA on that, but the back pay, anything that is tied to your income is taxable, but it's not taxable in the typical way. It's taxable at the highest rate, which is another
Oh,
source
really?
subject. Yeah, because when you're adding that kind of a lump sum income, you now
Oh, because you're
swell
not
up to like a
yeah,
luxury. It's almost like a luxury tax that you're having to pay,
you're right,
as
because you're not.
opposed
It's
to
not amortized over every year. You're paying in one lump
correct.
sum, which is a little bit of a kick in the balls, right? What do you
Well,
think about that?
it's a pretty big kick, you know. And we actually tried to get the court to allow us to include that in our judgment, and the judge excluded it. He did not allow that, which to me is like, that's further of an unfairness, to
Yes.
us, because it's like, okay, so yeah, you get this money, but you're having to now pay, I think it's like 37%
Yeah.
tax rate because of the lump sum nature of it, that you would have otherwise had it amortized over time and
Right.
paying a much lower rate.
Yeah, it's very
But
frustrating.
it's just part of our legal system.
Another question for you related to this. I'm just a finance guy, and I'm always fascinated by these details. So you win the case in February 2022, and they're appealing now, and here we are, literally over a year later. Are you eligible then, if you do ultimately win the case, to get interest or penalties on the fact that you didn't get the money for over a year? Is that also
Yeah, yeah.
okay?
There's interest on top. It's also, I think, governed by the statute. It's a small amount. It's certainly not, given the state of our inflation, it's not commensurate with the
So
inflation rate.
so you're losing again a little bit, right?
I'm losing
Because
again a little bit. And this is part of the dynamic, is that I think some defendants will appeal in hopes that the plaintiff will want to come to the table and settle. They have never extended, the city has never extended any kind of a settlement offer. There's never been any discussion. As a matter of fact, Brian and I, shortly after, he's like, okay, maybe this is a time to discuss something. And originally I was going to be inclined that way, but I'm thinking, and my wife was like, well, why would we, if they've not even broached the subject? So we're going to broach the subject that they have not even introduced, only to get further insulted. So we just kind of like said, you know what, we're not going to offer it. If they want to put something on the table, we'll consider it, obviously. But there's the dilemma, or the weighing of the present value of money versus the future undetermined
right.
value, because you don't know what an appellate court is going to do.
Absolutely. So your book, okay, so let's fast forward now to your first court date. It's basically in June or July of 2017, about 6 months after you're officially fired. And that's when you have your first case. And that's basically just to hear this BS dismiss, motion to dismiss the case, this,
Correct.
typical legal procedure. We don't really hear much in the book between that point and the actual court case or whatnot, but I'm sure there's a bunch of intermediate court case steps and stuff along the process. Can you just walk us through briefly the timeline to get from that first case or that first court hearing to the actual eventual trial?
There were the first, as you pointed out, the first hearing was in June of 2017, roughly 6 months after we filed the complaint. The complaint was filed January 25th of 2017, and then the first hearing date was in June of that year. The whole purpose of the hearing was a motion to dismiss. The defendant's counsel brazenly said to the judge, I haven't even read the defendant's complaint.
Yeah, you're talking about this.
Like,
You're talking about this Joker named Chris Stearns, who you're not a
yeah,
fan of, right?
yeah,
So
well, being not a fan is really like a compliment.
okay,
So
I bet.
yeah, yeah. So came to court unprepared. He came to court saying to the judge, "Hey, I haven't even read the plaintiff's complaint, but we're asking the court to dismiss the case. Just the fact that it doesn't have any merit." Which, for anybody who's never gone through this or understands the system, our judicial system, one would think that if you come to court and you say that to a judge, that the judge would say, "Get the hell out of my courtroom.
Right.
How are you going to come to
It's
me
disrespectful to the court.
to tell me
Yeah.
you haven't even read the plaintiff's complaint and yet you're coming asking for a motion to dismiss?" It's
Right.
almost like, you didn't even do your homework and you're coming in trying to. So it was just, the first introduction to how insulting the defendant's counsel was. And I also would say, if the city of Hallandale Beach had been made aware that their attorney that they hired didn't even bother to read the complaint and came to court unprepared, I'm thinking, is that a really good use of taxpayer dollars, that you hire somebody
Right.
who's not even really doing their work, and that
Yeah.
yet they're coming to court that way?
Because you
But
best believe he billed them for that
of course
appearance.
he did. Of course he did. And he probably billed them for, prep, court
Yes,
prep
prep work that he didn't. Yeah, yeah.
that he didn't really do.
Prepping his excuse is probably what he was
Yes.
doing.
Yeah. That's a really good way of putting it.
So
Yeah.
Daniel, that brings up an interesting point. This is a random question, but throughout this whole process, this goes on for years. Did anybody from Hallandale Beach, whether it was an elected official, the new city manager, city attorney, did anybody ever show up to court on behalf of Hallandale Beach as far as an actual person to see what was going on and observe what was transpiring?
Well, from that initial hearing date in June of 2017 all the way through trial, you asked me that question. What was occurring was a series of depositions and discovery. So
Okay.
both sides essentially are asking the other side, "Okay, show us what you got. Show us the evidence that you're going to present." That's the way it works. And you have all of these depositions. Now, throughout the 2.5, 3 year period, the city, with regard to the individuals who would be deposed, were constantly delaying and having to reschedule their scheduled deposition dates. So all of these depositions were like, okay, we're scheduled for a deposition, and I don't remember the exact dates, but let's call it October of 2017.
And these are well in advance.
These are well in advance
Right.
because we provide the list of all of the people that we want to depose. We provide, all of the questions and the themes of the things that our attorneys are going to ask. So a couple of days before, Stearns and his team would say, "Well, Commissioner so and so can't make it because he's got to, pluck his eyebrows," or whatever the lame
Right.
excuse was at the
Right.
time. So this happened over and over and over again. So I want the audience to understand that, you're thinking in your mind very linearly that these things are going to happen sequentially. They're going to happen one right after the other. And it's just like this long, dragged out process. And you get to your appointment date, your deposition date, and then they say, "No, we can't make it today. We're going to have to, move it again." All of those things are just continued emotional
Trauma.
attacks and
Yeah.
trauma because you can't get to the finish line. That's really what all that happened during that period of time. You have all of these, and you have various hearing dates for what's going to be allowed as admissible in court, what's not going to be allowed as admissible in courts, all of the hearing dates to kind of the structure of the trial, etc. It's all very technical. It's all very part of the process, but it's very tedious. And that's when you realize, without qualified, experienced representatives, this would be not just deep water, but this is shark infested, really tumultuous,
Yeah.
waters that you get
Yeah.
into because you just don't understand.
No chance for a
Um,
layman. No
no,
chance
no,
for a
no,
layman. Yeah.
none whatsoever, none
Yeah.
whatsoever.
At one point in the book, you talked about how when your attorneys came aboard, they gave you instructions. One of the instructions was, "Hey, you need to continue looking for work, and you need to document that." What other types of stuff were you instructed to do and prep and how to handle yourself? I mean, you had one other legal counsel advice. It was like, "Hey, you need to realize that this is going to go on forever. Like it's going to go on for a long time. So you need to just sort of forget about it and move on with your life and just sort of put this in the side, in the back pocket, so to speak." Can you elaborate a little bit more on what kind of instructions or feedback or counsel you received just on a personal basis, not like on your legal case, but how you're supposed to, just carry on, because this is a tough situation for someone who's never been in it before.
The gentleman that actually mentioned, just kind of going on with life was Freddie, my friend and the initial attorney. And I write about the fact that, when he said that, my wife and I were both in his new office because he had just opened his own practice. I had this kind of wry smile, like playing it off. But as my wife and I got in the car, neither one of us said a word. We were both like really angry, but not at each other, but what
Right.
was happening. When we finally did talk about it, it was just like one of these things where in your mind you're thinking, because I think most people have this vision of a court case happening kind of like it happens on Law and Order, right? You
60
start
minutes,
with
right?
60 minutes with commercials, right? So so you're thinking this is going to be quick. You hear about people that do something today and within a year they're in trial. So in your mind, you have this expectation of length of time and process for how all of this is going to happen. And when Freddie said that, it was literally, you get the wind knocked out of you because you're like, man, 2 or 3 years. And at the time he said that 2 or 3 years was like forever. If he had told me
Right.
7 years, I literally would have jumped in front of a moving train. It's like,
Yeah.
there's no way that we can sustain this situation for this length of time.
And I think there's an element to it too, Daniel, when you feel like you've been wrong so severely, right? So egregiously, right? That, you talk about even kind of good versus evil in pure evil in your book about this personal attack on you and your career and whatnot. It's like you just have this sense of right and wrong. Like, this is not the way it's supposed to be, right? It's supposed to be,
Correct.
justice is supposed to happen faster than this, right?
Yes.
And it doesn't.
And it doesn't.
The legal system is very slow, and
It's very slow, and it's very, in many elements, Joe, very unfair. I would not bore the audience with a lot of the details, but I will tell you that there were many things that we wanted to be introduced as part of our claim during trial that the judge says, no, we're not gonna allow that, and we're gonna dismiss that. And it's like, and so your legal team prepped all this, has all of this documentation, it's evidence, and because the other side objects to it and the judge makes a decision right there on the spot and says, nope, it's out.
well,
And it's like,
we might be getting too much into the weeds here, but there was I didn't understand why the Lynn Whitfield case materials were not really allowed to be fully introduced, because that was essentially the entire genesis for why you're even in the courtroom in the first place, right? I mean,
well, and
at the end of the day, Dan, I didn't ask you this in the first episode, Daniel, but at the end of the day, if you had not provided any testimony in that investigation on Lynn Whitfield, do you think you would have gotten fired on November 29th? Or do you think
no,
that was going to happen? You think you would have survived that?
yes,
Okay.
for
You think
sure.
for sure you putting your name on the line and calling out Keith London in that investigation, that sealed the deal for you. You were done at that point, right?
Yes.
Yeah.
There's no doubt in my mind now to think that he wouldn't have come after me for something else
At
and
a
would have
later
said, hey,
date. Yeah.
I want my own manager, or I want somebody different. Very, very possible, because that's just the type of person that he is. But I don't think it would have been a termination with cause and being accused of all of the things that I was accused of. So it would have definitely gone down. If it went down, it would have gone down very, very differently, for
Right.
sure. So you
And so,
asked me, you
yeah, the
wanted,
judge doesn't let this in. I'm like, why isn't the judge letting this in? This is ridiculous.
well, he didn't let that in. We had intended in our opening statements to introduce Annabelle Lima Taub's, the video clip of her apologizing in a public meeting,
Right.
saying that it was pure retaliation against Mr. Rosemond and
Can
against
you
Miss Whitfield.
Yeah, yeah. So I'm sorry, I stepped on you there, Daniel. But can you just repeat that? Because essentially, this was incredible. Because I'm reading the book, and this is in 2018. So basically, 2 years after you're fired, for whatever reason, Annabelle Limatab, she goes into a public council commission meeting, and she basically says that you were wronged.
Well, it's not for whatever reason. It was after her deposition. so,
Oh, okay, 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 okay. I missed
so
that part. I missed that part.
well, her deposition. What I enlighten readers about in the book is that a lot of times elected officials can grandstand when the cameras are on during a commission
Public
meeting,
hearing. Yeah, yeah.
but in a deposition, it's a different story. You can't grandstand. You can't spin the truth. You either tell the truth or you could be accused and found guilty of perjury. So the evidence was presented to her, and she really could not get away from it. So it was after her deposition that she comes and gives this public statement about the now obviously she doesn't frame it that way, but that's what it was. So she says, I was misled by Keith London. And of course, they had their own falling out, but she comes on the record and says it was pure retaliation against Mr. Rosemond, against Miss Whitfield, and I'm sorry. So she has this apology. So my attorneys during trial wanted during opening statements to include that entire, I think it was a minute 20-second clip, and the judge said, no, you can't introduce it during your opening remarks, but when she is on the stand, you can play a portion of the clip. So stuff like that, that you think it's a slam dunk, is not always a slam dunk because you are at the behest of whoever the judge happens to be.
Right, right. And so, were you able to get all three? I assume you got all three of the commissioners on the stand and during the actual trial, right?
Yes, yes. All three that voted to
No,
terminate
that's
me.
what
Yeah,
fire you. Yeah, yeah.
yeah.
I'm curious because you don't really talk about it, but how did Keith London do? Was he was he a good witness or was he?
He
Do you
he
call that?
was I do listen. This is one of those things that you're never going to forget. He was in true Keith London character. He was being a jerk and being evasive and being at times uncooperative. Even to the court's instructions about speaking into the mic. And every time that my attorneys would ask a question, he's like, "Would you repeat the question? I don't think I understand the question." And it's
Uh
like,
huh.
just being a total douchebag, right? So he was being his true self. And it was interesting as I observed a little bit of the body language and seeing how the jury was responding to this from my vantage point. You could tell after the first 7 or 8 minutes, they were like, this guy's, like
He's
you could
helping
tell,
you.
like,
He's probably
yeah, he
helping
was
you, right?
helping me.
Yeah,
Exactly.
yeah,
The
yeah.
way that he was responding and the way that he was just evading a direct line of
Right.
questioning really favored our case because you could tell, like, if this guy really had,
If he's gonna act that way in court, how's he gonna act in private with you? And
right,
yeah,
right, right,
absolutely, yeah,
right.
yeah,
So all of those things were a factor. You had asked me earlier in terms of the timeline after the July 17th, I think, meeting, right?
yep,
You had asked me what transpired in that time. As I mentioned, it was all a series of depositions and a series of discovery, and all of that stuff is really what comprised that kind of that block of time between
yeah,
the original complaint and when we finally were able to get to court. But
yeah.
but they had also, my attorneys had also asked me to document all of the job applications that I had to pursue, because part of the back pay is that you have to demonstrate a concerted effort to regain employment.
Right. You can't be
So
sitting on a couch at home eating bonbons and
exactly,
watching movies, right?
exactly,
So
exactly.
yeah,
So going through that, and I had a pretty, I won't call it sophisticated, but I had a pretty organized spreadsheet of jobs that I had applied for, both private sector, public sector, nonprofit, universities, whatever categories, down to the detail of the person that I reached out to, or the website that I pursued. And all of those things were introduced in court to demonstrate my compliance with, demonstrating a good faith effort to find gainful employment. And one of the things that I think listeners would be interested to know, or need to appreciate, is that when you go through something like this, you mentioned about the wrongfulness of what has been done to you, and you're still having to apply. And in those applications, as anyone who's applying for a job knows, one of the key questions that they're going to ask you is, have you ever been terminated from a previous employment? So you're having to say yes. And then within a limited number of characters, you're having to say what the circumstances were,
yeah.
rising to that
You
termination.
there
It's like, how do you explain that?
there. It's such a degrading experience, right? Because when you're a city manager, you're applying for a job. You're almost always asked at some point in the process, were you terminated or did you have to resign or whatnot? That comes up, right? Or you even have to
Right.
disclose it yourself. But you usually get it a different context or a format, or get an opportunity to expand on it. Here you're relegated to, and I don't want to denigrate lower income work or anything like that, but you go these traditional applications. You're right, you get this little tiny box and everyone knows, like, how do I put my story in this little box? Who's
You
going to believe
can't.
me anyway, right? Who's
Exactly.
gonna It's like you're getting victimized over and over throughout this entire process, emotionally, your pride, your dignity as a man, taking care of your family. And
But
go
Joe,
ahead.
not only is it that part what you just described, I know several HR executives who say when you're looking at a high level executive position, department director on up, once you tick that box that says you've been terminated, your application literally gets moved to another pile.
You're tainted. You're tainted.
It's like
Yeah.
you're not, because if you've got other
Why take the
candidates to
risk?
consider,
Why take the
why
risk?
what's so special about this person when
Yeah.
you've got 5 or 10 other people that you can consider? It's like, okay,
Yep.
move them over.
It's
And
why take the
so
risk? Yeah.
you're having to go through this process of continually applying,
And getting beat
knowing the
up.
outcome. So it's an emotional, like putting your heart and your emotions through a meat grinder continually, because you're having to show that you're making a good faith effort. So it's just really tumultuous.
And when you feel like you are the innocent victim here and you're getting wronged over and over, it's just, man, I felt so bad for you in so many parts of the book. I mean, you have this one section in your book where you talk about going into Costco, like,
Mm-hmm.
you know what I mean? And no offense to Costco workers and like that, but it's just like, you're a city manager and here you are going into Costco to try to get a job, and you can't even get a job at Costco because,
Yeah,
probably because they're like, hey, why are we going to hire this guy? He's overqualified, or it's this whole mind effort. You know what I mean? It's just,
and all I was really trying to do was to find. I mean, I was thinking I could be a gas station attendant if I can at least get insurance for myself and my wife.
right.
Then okay, it's not where I want to be, but at least it's a interim, means to an end. And it was really, as a husband, it was a hard thing to see how my wife reacted to it. Seeing me walk in there with my folder with my resume, going to see the manager, and she's like, I can't even remember what she said because it was just very raw at that moment, having
Right.
to experience that. But I needed to include it because I think the readers and people in our profession need to understand this is the risk. These are the vulnerabilities. I would have never thought that I would see myself going into Costco to apply for a job just to get insurance. I would have never saw myself as a rideshare driver. I would have never seen myself as someone willing to take whatever just to put food on the table and to regain a little bit of that dignity that was taken away from me.
Right.
But yet that's where I found myself.
Getting back to your trial, I'm kind of curious about this. So it was like roughly a 9-day trial, and you're going through it, and you're in there every day. Obviously, it's your case. I'm sure
Mhm.
you're super invested, and each day passes. Do you have some sort of debrief with your counsel afterwards, and they give you a play by play of how they felt it went, or you have this interesting deal in your book too, unrelated to the trial, but it's appropriately related to this question. You talk about you get home from work or something. It's a long day at the office as a city manager, and your wife wants to ask you questions about how your day went. And the last thing you want to do is regurgitate everything you just went through, right?
Right.
Right. And I'm sure some attorneys don't want to regurgitate everything that happens to their client after the case because it's been emotionally, mentally draining and exhausting, right? But
Right.
can you walk me through the dynamic between you and your counsel after each day of testimony and how that played out? And were you getting a play by play? Or were they playing it close to the vest and just saying, "Hey, everything's fine"? Or can you walk me through that a little bit?
There was very little conversation outside of just the very casual conversation. First of all, they had to be adjusting their game plan because of the amount of breaks and the inconsistency in terms of the start times for the trial. And so we had a slew of, not a slew, but a larger list of witnesses that were supposed to be called, which we had to be adjusting based upon all of the motion for objections and the motion for a mistrial that Chris Stearns lodged. And so we would have to have recesses to deal with that. And every recess that the judge called for, the jury gets dismissed. And then you have this hearing that could take anywhere from 10 minutes to 40 minutes. And then the judge goes back in chambers and stays there for another 20 minutes. And then before you know it, it's an hour, hour and a half. So you factor all of that into a already shortened day of trial, and it becomes very, very long. And so at the end of each day, my attorneys said very little. I couldn't really talk about what had transpired because my wife was supposed to be one of our witnesses, so I couldn't really tell her what was going on.
Oh, I didn't realize that. Okay,
Yeah.
that's an interesting dynamic. So you're kind of on your own little island by yourself in a lot of
Yeah,
ways,
man. And
right?
I had to really just kind of like swallow that. And anyone who, when you've had a rough stretch, even as a city manager, even though you're dog tired, it's really hard to sleep. So exponentially, I would get, not home, but to the Airbnb that we were staying at. I would get to the house and I tried to relax, and it was very hard to relax. So I got very little sleep during those nine
I
days
bet. Yeah.
because, you're just replaying everything that you had heard, and then you're anticipating what's going to happen the next day. And you're seeing the discussions amongst your legal team, and you're seeing how they are making adjustments on the fly, and you're wondering, I don't really know how this is going. It's like I think
Right.
it's going well, but I'm not really sure. And then there were moments that I'm like, this is not going well at all because it was not what we wanted, and the judge made a decision that was not what we wanted. And so you have this kind of roller coaster up and down set of emotions that are happening throughout this 9 day period.
Well, that kind of dovetails into my next question, and that is in your book, you talk about essentially as the trial's concluding and wrapping up, that you were essentially at your lowest sort of point of confidence in how the case was going. That
Yeah.
you weren't thinking things were going to go well for you. Can you elaborate on why you felt so beat down at the end of that trial? Because ultimately you end up winning, so obviously that's spoiler alert. That's great news. But right, you right before the end, you were pretty beaten down and not very confident in the outcome. Why was that?
The two reasons. One was the set of jury instructions was akin to probably three yellow phone books, right? So really, really not the legal instructions, but thick evidence. So all of the documents that have been presented during trial were all part of what the jury was going to take back into deliberation. They also had a very lengthy jury instructions, like 27 pages worth of jury instructions. And when you look at the composition of the jury, this is not, as I think I write about, this is not like a John Grisham novel where you have very intellectual individuals. This is a cross representation of people in the county. And while I remember all of the interviews, I could tell you that there were not a lot of folks who were at an executive level position who would understand the nuances of an employment agreement and all of the information that was presented, let
Let
alone.
alone the context of how this is
There you
all.
go.
Yeah,
There
yeah,
you
yeah,
go. And
yeah.
and so my confidence was really at its lowest because of all of those factors, and because the second reason, because the defense counsel was objecting to the way that certain language was written in the jury instruction, which caused a further recess, and then them having to agree on the language. Both sides had to agree on the language, and then the judge allowed that. And so when that part was read, I was looking at the way that the jury was, their body language and their engagement. Remember, most jurors, when they serve on jury duty, they're thinking it's going to be a day, max 3 days.
Yeah,
My
yeah.
trial was 9 days.
Right.
So three times the length of what people would typically expect. So they were really tired. They were exhausted. They were overwhelmed in terms of the information I could tell. And it was just, I didn't think that they were going to really understand it. And so they were just probably going to dismiss the information, and there was going to be discord within the deliberation. So I was really at my lowest point. I'm sure a lot of it had to do with, my fatigue at the time myself. And the fact that my attorneys were not super exuberant saying, we got everything we wanted.
Yeah,
It went great. It's like,
yeah, yeah, yeah.
so I was really thinking, I don't know. The only thing that I was grateful for was that we finally had our day in court, and we got to at least tell a version of the story to independent jurors. But I honestly couldn't tell how it was going to go.
When you're on the stand testifying in your own trial, right? Inside baseball? Are you coached in any way by your legal team as far as how to your posture, your where you're supposed to make eye contact? Are you encouraged or not encouraged to look at the jury members in the juror box? I mean, is there anything that goes on in that dynamic when you're going into such a important case like this? What's the prep like?
There was a little bit of that. I mean, we went through the questions that they were going to ask me. For the most part, there were a couple of questions that Brian, who was the one that on our team, the one that questioned me, he says there's a few questions that I'm not going to prep you on because I want it to be a
Authentic?
genuine, an
Yep.
authentic reaction. It's interesting, during one of the preps with my testimony, they wanted to know whether I would be willing to say, with regard to the use of the P card, whether that was a mistake on my part. And so that was a discussion. I said, no, I don't want to go that route. And this was the first time that I had kind of I wouldn't even say kind of pushback. It was just a disagreement in philosophy. And I said to them, look, if I say it was a mistake, then I'm almost admitting to doing something wrong. In my
Right.
case, it was not a mistake. It was intentional.
It was above board. Everything, it was
It
all
was above
discussed.
board. I said
Yeah.
that I was going to take my daughter. My boss at the time had okayed the travel request, and whatever her expenditures were had been reimbursed to the city immediately upon my arrival. And I wasn't even the city manager at the time, so it wasn't even anything that I needed to apologize for. So I pushed back and I said, no. If you guys ask me out on the stand, I'm going to say exactly that. This is not anything that was done inappropriately. And so they said, okay,
Yeah.
we'll go your route. And
Good.
so that was the only time that there was a little bit of a disagreement in terms of philosophical approach. But for the most part, the only amount of coaching was, just try to make sure that we're having a conversation, but at the same time, make sure that you're making eye contact with the jury from time to time.
Okay.
That was it.
And during your testimony and also during the trial, you alluded to a little bit with London how the jurors didn't seem to respond very well to him. But were you able to make eye contact with the jury? Did you were able to get a vibe or a sense of where they might be in this whole situation as far as where they came down, or were these just
Man,
like poker players?
they were really hard to read. There were a few of them that there was one, and that she ended up being an alternate juror. She worked for the Broward Sheriff's Office, and she worked in an HR capacity. And she was the only juror of the 8 jurors. There were 6 regular jurors and 2 alternates who was taking ferocious notes. And because of her background, I'm thinking, man, I really hope that she ends up being the chairperson of the jury pool, because I'm thinking she's going to at least get it from the standpoint of what an employment contract is and how many times the city violated their own policies, etc. But no, they were really hard to read. Granted, this was still somewhat post COVID, so several of them had their face masks on. And so all I could see was their eyes, and I couldn't
Right.
really tell. A couple of them were falling asleep during some of the testimony, which did not bode well for their engagement. So
Right.
all of these things contributed to my feeling of this thing is not gonna go well at the end.
So something I was a little bit unclear of, and first of all, it's interesting because in the book it talks about there's 6 jurors and there's 2 alternates, which I thought
Mhm.
there was going to be more than 6 actual jurors. Did you need to get all 6 a unanimous verdict, or was it a
Yes.
plurality? So you need to get all 6.
Yes.
Okay.
Yes.
Wow. Okay. So
Which contributed, as I said, to why I was feeling the way that I was feeling, because I'm thinking there's no way that all 6 of them are going to understand the voluminous amount of evidence that had been introduced, be able to understand and agree to the 27 pages of jury instructions and come back with a unanimous verdict in my favor.
right. So the trial wraps up, and you guys exit the courtroom or whatnot because the jurors are going to go deliberate.
Hmm.
Walk me through what's going on with you and your legal counsel then, because there's always weird theories about, okay, if the jury comes back really quick, it's good or it's bad. There's all these different schools of thoughts and what have you. So did you and your legal counsel talk when just walk me through, or was everyone just sort of in their own little headspace and just waiting for
Yes.
the
It
okay?
was it was very quiet. It was a Friday afternoon, and it was on the 14th floor of the Broward County Courthouse. And
Because I'm thinking you probably got thinking you're be coming back on Monday no matter what, probably because it's late in the day, right? I mean, do you think you're
no,
good?
no, the
Did
judge had already said this trial ends today.
oh really?
Yeah, so they were going to have to deliberate until they came back with
Oh
a
wow.
verdict. Yeah.
Okay.
So we were there, and everybody was kind of in their own. A couple of people checking their phones. People, a couple of my team. I think one of the team members stayed inside the courtroom. Another one had just kind of walked down one hall. My wife and I were sitting on the bench, not saying much to one another. The defense counsel was kind of doing their own thing as well, but no conversation, nothing strategy, or if they come back with this, it was very
Just wait.
just wait. And it was a long hour and 10 minutes, man.
I, I bet it was, but yet it was only an hour and 10 minutes, and they come back, and I can't even imagine. So, I mean, we've all seen court cases on TV. We've all seen them like in real life. We've all seen the movies or whatnot. I mean, you are coming to the finish line here. You're 7 years in, right? Essentially,
Mhm.
6 years or whatnot in
Six
at this
years.
point,
Hmm.
and you have to wait for this verdict to get read. Like,
Yeah.
Man, can you even
There,
summarize that emotional sense of where, I mean, what are you thinking or feeling in that moment? How do you even put it into words?
Joe, to be quite candid, there was really very little thought because my heart was pounding as hard as I ever felt my heart pound, and I really couldn't process what was happening. I knew it was standing up because obviously when the verdict is read, everybody stands up. As the clerk is reading the various, because I think there were 8 different questions that they needed to respond to. There was one question that we had asked the jurors to say yes to each question except for one, where they had to answer no to. And that was the only thing that I remember was important. It's like, okay, question number 4 has to be no when all the other ones are yes. But as the responses from the jurors are being read by the clerk, I am listening to each response and I'm watching, kind of like looking over at my attorneys, and they're putting their head down with each response. And I'm thinking their body language seems to be that this thing
Defeated?
is not going well.
Yeah,
This
yeah.
thing is like not going well. And in my mind, I'm like, what is happening right now? What is, I just don't even hear anything.
Right.
And the only time that my, kind of like it perked up when they put in the amounts that the jury had awarded, then I look at my Brian, and then Robert starts crying as well. And I'm like, okay, wait, what is happening?
Because if I
Did we
lost, they
win?
wouldn't be putting numbers in, right?
Yeah,
But oh, but I'm sorry to interrupt you there too, Daniel. But I'm sure the last thing in the world you want to do is jump to a false conclusion of victory at this moment because you don't
yes,
want to allow you're so vulnerable and you've been guarded and protected yourself. The last thing you want to do is get your mind in a place where you think you've won and find out you've lost, right? That'd be like horrible.
it
I think
was it
that's
was it was tremendously inconsistent. I mean, I still have not been able to process exactly the emotions. I tried to articulate it as best as I could, in the book, but honestly, there were so many versions of that moment, that scene, that I just tried to make sure that it could be coherent to the reader. But honestly, what was happening inside me was completely chaotic. And then I looked back at my wife, and so she's completely flushed, completely crying, and I'm thinking, this we I don't know what just happened.
right.
But it was a real moment that it takes you, I think, a few moments to let it process before you can understand exactly what occurred.
So you have this victory, right? Obviously, it's a euphoric sense of feeling a wave of emotions and whatnot. And like we talked about earlier at the beginning of this episode, but it's not in the book. Then you have to have this, bench trial with a judge
Hmm. Front
for the
pay.
front pay, what
Hmm.
have you. Can you walk us really quick through the process of after the verdict and kind of going to that step and just sort of was there anything interesting that transpired at that case or that bench trial that was worth noting in this conversation?
Nothing interesting other than, us my attorneys reaching back out to the judge post the verdict saying, hey, we had wanted a bench trial. When can we get on your calendar to be able to have that hearing?
Is this
Because it
the
was
same
supposed to
judge
be
that heard the
the
first
same
case?
judge, Judge
Okay.
Robinson. Yeah, it
All
was
right.
supposed to be at that same time, but because this was already Friday afternoon, he's like, well, we're not doing it now. So reach back out to my office and we'll try to get you a date. And it ended up being July of 2022 when we were
Okay.
able to have the bench trial. So as I said, between February of 2022 and July, nothing really significant other than just, again, just waiting for that bench trial and waiting to see the outcome of that.
And I assume you were fairly confident going into that bench trial just because you just won your case and the judge
Right.
was there. I assume you guys were pretty confident at that point, right?
Yeah, and I actually even asked that question. I'm like, I asked Brian. I said, "How does the verdict play in terms of the bench trial?" He says, "Well, it plays. Obviously, when the jury is awarding you the back pay and the wrongful termination, that is a tremendous springboard for the claim of your eligibility for front pay.
Right.
It's going to ultimately be up to the judge to determine how much front pay you get. But the fact is, you're likely to get something because of the jury's award."
And I assume that once you got the February victory and then the July, even before the July bench trial or whatnot, I'm assuming that your counsel was like, "Hey, expect an appeal from Hallandale Beach. They're probably going to appeal." Like that's pretty much a given, right? At the
Yeah.
point. So you were, even though you're celebrating, you weren't naive enough to be thinking, "Oh, I'm going to be cashing a check in 30 days or something like that."
No, and my attorneys had actually told me that when I did my deposition in December, they said, this is likely going to be another 2 years after the jury trial, simply because that's just par for the course. Either side is going to submit or request an appeal to whatever the outcome happens to be. In my mind, I had heard it, Joe, but I had actually wanted that not to be the case. I'm thinking maybe cooler heads will prevail. People will come to their senses, and we'll get to the end of this thing before. But that's not the case.
Understand, yeah. And so, as we wrap up this episode, Daniel, part two, Revenge of the Public Servant, where you beat them in court, you got a massive victory. Obviously, you haven't cashed the check yet. You've gone through a long ordeal here. Do you have, something you'd never found yourself in, never expected to be in, but you've now lived something that most of us will never live? But there's going to be other people listening to this podcast that are either in something similar at this moment, or they're going to be in something similar down the line.
Mm-hmm.
What are your major takeaways or learning experiences about how this whole thing unfolded, and what would you from a legal standpoint, what would you have done differently, or would you have done anything differently?
I can't say that I would have done anything differently. I really will candidly say and honestly say that the idea of good legal representation is critical. I've heard so many people through LinkedIn respond to me telling me, I went through not as bad of an ordeal, but a similar ordeal, and I didn't have good legal representation. So, to your point in some of your previous episodes, as city managers or people in this profession, don't be naive into thinking that you can just get anybody, because when you get into these tumultuous waters, you better be sure you have really good legal representation that are going to be experts. If it's a labor issue, don't just get any old attorney. Make sure that it's somebody who specializes in that field, and someone who's going to have your best interest. Look at their caseload, look at their past, portfolio. Same things that we would do as administrators, right? You want to
Yeah,
vet the professional that's going to be representing you, and then just really, I think the takeaway is be prepared that it's going to last much longer than what you anticipate. Because in my mind, that was one of the big misconceptions. I'm thinking that it was going to be, a 60-minute episode,
right,
right?
right.
And I had no idea that it was going to be much longer. So when you are treading into these waters, you better be prepared financially, emotionally, and everything else, both you and your family, for a very long road of litigation.
Absolutely. And we talked about this a little bit in the previous episode, and I've talked about it before, but I do think that we as city managers, public sector executives, need to be more proactive in preparing, playing defense, right? Whether it's our
Mm-hmm.
negotiations for a contract, we should be more protective and trying to minimize or mitigate the risk, minimize the downside risk exposure that we face. And I think also same thing can be said for our attorneys, our legal counsel. And I'm speaking from this is, I'm guilty of this right now too, because I don't know who I would call right now if I was to be in a similar situation that you found yourself in. And I think the key is that probably city managers need to be thinking about, okay, what am I going to do if I'm in this situation? Who am I hitting in the quote unquote Rolodex that's going to help me? Because you talked about it earlier, and I don't want to belabor the point, but just because you think you can call person X doesn't mean that person X is going to be able to help you, because of the way this industry works and how tight knit it is, and there's conflicts and so forth and so on. So just because you think you can call this individual to help you, or this law firm even to help you, that might not be the case. And so I think we need to be a little bit more proactive in preparing ourselves for a worst case scenario, instead of just being reactionary in the moment. You have some thoughts on that?
Attorneys that understand the nuances of local government are often getting their bread buttered by local
By local
government
government.
clients.
Yes,
So if you ever need them to advocate or represent you as an individual plaintiff, the chances of them taking the case are very, very small. And so that brings unto itself a very lonely feeling and a real dilemma, because you have to engage someone who doesn't understand the complexity of how government works, and so it becomes very, very difficult.
I bet it. Exactly. Exactly. Very well said, Daniel. Well, you've walked a line that many of us have not walked. So thank you for sharing your experience, Daniel. I think it's going to be very useful for a lot of individuals, even just the last couple of minutes where we talked about being proactive with your legal counsel instead of being reactionary. I'm Joe Turner. I am the host of City Manager Unfiltered, a podcast by a city manager for city managers and other public sector executives. My guest today has been Daniel Rosemond. He's the author of Death of the Public Servant. And we're going to come back again with part 3, Betrayal of the Public Servant, where we're going to talk about his appeal and some other aspects to this whole saga that many of you are not aware of. It's going to blow your mind. I think there's a lot of things about this situation that many of you do not know, that I didn't know, and I think we need to have some discussions about. So thank you, Daniel, for being on the show. And until next time, catch you later.